In the last lectures, we have seen the definition for the term of expression trust. There are different English authors define the term of expression trust in a different form. But in terms of Section 3 of the Trust Ordinance, trust is an obligation annexed to the ownership of the property and arising out of the confidence reposed in and accepted by owner or declared and accepted by owner for the benefit of another person or of another person and the owner of such a character that while the ownership is nominally vested in the owner, the right to the beneficial enjoyment of the property is vested or to be vested in such other person or in such other person concurrently with the owner. Now, when you summarize this definition, we simply say there is an obligation arising out of the confidence reposed by the author of the trust for the benefit of beneficiaries or other persons. Then when you say other persons, it may include owner of the property or author of the trust. That we have seen in the last lectures. Today in this lecture that we are going to see the similarities and differences between the trust and other legal concepts. First, we will see the distinction between trust and contract. Now we have seen what is known as trust. Definition we have seen. When you see contract, a contract is an agreement enforceable by law. Again, here there is a similarity. Enforceable by law. Even when you see some authors, English authors said that also one of the arrangement enforceable by law. Then it should be for lawful purpose. Then a contract is an agreement enforceable by law. Entails an obligation or legal duty to do or abstain from doing something what one has promised to do or abstain from doing. A trust results from the act of parties, though some of the characteristics of a contract, but it differs from a contract with respect of beneficial interest in and legal ownership of the trust property. When you talk about contract that you have studied already, contract is a promises between the parties. A contract is a bilateral agreement. Generally, contract is a bilateral agreement resulting from an offer and an acceptance of that offer and consideration passing between the parties. As we have studied, there must be an offer, then and thereafter an acceptance for that offer and the consideration passing between the parties. An express trust arises from the unilateral act of settlor or the author of the trust in declaring a trust. There is no contract between settlor or author of the trust and trustee in ordinary circumstances. There can't be a contract in between trustee and settlor because settlor, the author of the trust, transfers his property to trustee. That is the end of the scene. Then thereafter nothing Nothing at all, because once the property transferred, absolutely the legal owner of the property is the trustee. Then the author of the trust more or less out of the picture. The contract does not form part of the trust. A contract creates personal obligation between two contracting parties. If there are so many parties to the contract, then it creates personal obligations between the parties. Those parties can sue one another for damages for the breach of contract that we have studied. The rights to damages arise in common law from very existence of the contract. When there is a party promises to do something, if they violate, then the other party can sue for a claim. In relation to trust, there are personal obligations between trustee and beneficiary in relation to the treatment of the trust fund and performance of the trustee's obligations under trust. Here also obligation, there also obligation. Here also personal obligation, there also personal obligation. But that's because of the contract, this is something because of the equitable principles. That's why there's a personal obligations between the trustee and beneficiary in relation to the treatment of the trust fund or trust property and performance of the trustee's obligation under the trust. The trustee will be liable to the beneficiary both to reinstate the trust fund and for the compensation if there is any breach of trust. The beneficiary is also entitled to require the trustee to carry out his obligation. And this is the contract and the trust obligation. Trust is an obligation that we have seen annexed to the property. Trust is an obligation to use one's property for the benefit of another person in whom it is concurrently vested. Beneficiary has more than the personal right against the trustee for the performance of obligations of the trust. He has beneficial interest in the property, though legal ownership vests in the person holding a property for the benefit of trustee. Even though the trustee is the legal owner of the property, he is under obligation to look after property, to safeguard the property and perform the obligation as it is specified in the deed of trust. Therefore, the personal right against the trustee, if the trustee violates or does not perform the obligation of the trust, then beneficiary has the right to file an action. He has the beneficial interest in the property, but the ownership of the property vested in the trustee. In a trust, trustee must hold the property for the benefit of beneficiary. That's a clear idea that we have studied. And the trustee may be one of the beneficiary. Similarly, results may be obtained where A promises to B to pay money to C. Now here, once again, where the trustee must hold the property for the beneficiary, fine. The trustee may be a one of the beneficiary. Similar results may be obtained where A promises to B to pay money to C. Here also, author of the trust transfer the property to trustee, the beneficial interest should be paid to beneficiary. But A does not perform the contract. That's a year. That's when you talk about contract. In the case of contract, where when A does not perform the contract, B will be entitled for the nominal damages. Why? Because he has suffered no loss. Because A promises to B. B does not get any gain out of these promises. Then he can't get any substantial damage for the promises made by A. At the same time, C cannot sue because no consideration has moved from him, or in other words, he is not a party to the contract. Because A promises to whom? B. But if A fails to do the promises, then B can't file an action because he promises to B to give some money to C. Then B can file an action for the nominal damages, not to the substantial damages, because B does not suffer any loss. At the same time, C can't file an action because he is not a party to the contract. But the situation will be different if A promises to B that A will pay the money to B on the condition that the money will be paid to B, paid by B to C. Now earlier one, A promises to B, I will pay the money to C. But here not like that. A promises to B that I will pay the money to you, B, on the condition that that should be paid to C. Here, B will be entitled to the substantial damages for the breach of contract. Breach of contract by A. But C is without remedy. However, C is a joint promisee, then he will be able to sue against A. It is sometimes difficult to distinguish between the trust from a contract because law of trust and law of contract are at places overlapping. In trust, there is a fiduciary relationship between the trustee and beneficiary. The beneficiary has a right to sue against the trustee for the benefit or for the proper maintenance of property or safeguard the property. In a contract, as specified earlier, C cannot sue against either A or B. The earlier example that we have seen, because C is not a party to the contract. In trust, there is a particular separate fund which the trustee has to preserve intact. In the case of contract, there is no necessity to have a separate fund. Prima facie, then there are some similarities in form between the trust and contract in terms of the existence of personal obligation between the parties. Nevertheless, there are three significant distinctions between the contract and the trust. First one, a contract creates proprietary right or rights in favor of the beneficiary. Secondly, the obligations which arise in a contract are created by common law intention of the parties, whereas the trust obligation arises because equity acts on consents of the trustee. Thirdly, the trusts impose fiduciary obligation in relation to specific property, whereas contract ordinarily do not. When we move to other slide here, in a trust, trustee cannot sue the trust property for own, cannot use that trust property for his own benefit. If he does so, then he commits breach of trust. Because trustee should not get any benefit out of the trust property. Trustee cannot use the trust property for his own benefit. If he does, he commits breach of trust. A trust is exclusively for the benefit of beneficiary, who is a third person to the contract between the author of the trust and trustee. Because when you say contract, when you use the word contract, that is in the trust, in the case of trust, in between author of the trust and trustee, there is no beneficiary at all. But when you come to the trust exclusively for the benefit of beneficiary, who is a third person to the contract at all. That's why no trust is created. That's why otherwise, if you don't do in this manner, there is no trust at all. That is, there is a trust, a transfer to the trustee, then a trustee must hold the property for the benefit of beneficiary. If you don't do this one, then there is no trust at all. In the case of Indian Iron and Steel Company, it was observed trust is in its origin was a form of contract distinctly enforced in equity. Trust in its origin was a form of contract distinctly enforced in equity. Then the idea here, even trust is a contract, but enforceable in equity. A contract creates a trust when it has brought into existence an obligation annexed to the ownership of the property for the benefit of a person other than owner. No technical words are required to create the trust. That we have seen. The last lectures we have seen, even without using the term of expression trust may arise. Because of the action, because of the words that they have spoken, trust may arise. That's why there is no technical words are required to create the trust. Question is fundamentally a question of the parties of the contract. Then where the fiduciary relationships created in a family arrangement in favor of strangers, then the strangers upon whom the benefit is conferred can enforce it as said family arrangement creates a trust in favor of strangers. Now there may be a family arrangement to give some sort of beneficial interest to so many people. That's an arrangement in the sense that's a contract or agreement. But stranger upon whom the benefit is conferred can enforce it as a family arrangement or agreement which creates a trust in favor of those strangers. Now we will move to see the distinction between trust and gift. A trust differs from gift in the sense that a gift requires a delivery of property and complete transfer of title. While a trust, legal ownership vests with the trustee, though for the benefit of beneficiary. The role of the declaration also comes into focus when self-declarations are compared with the gift. A gift involves the outright transfer of a property rights in an item of property from an absolute owner of those rights to a volunteer. The recipient, that's a donee, becomes absolute owner of that property as a result of such transfer. In some sense, the beneficiary appears to occupy a similar position in relation to a trust, in that the settlor transfers absolute title in the property by dividing between the legal title vested in the trustee and equitable interest vested in the beneficiary. Now, when you compare this one, generally in the gift, the absolute right of the property transferred to the donee. But here also, the author of the trust absolutely transfer the property to trustee. But here, the legal title transferred to the trustee, equitable title transferred to the beneficiary. In that sense, the settlor has transferred all of the property rights away from himself. The beneficiary is not required to have given consideration for the transfer. In that sense, beneficiary is volunteer. One of the core equitable principles already considered is that equity will not assist a volunteer. However, the significant difference between a gift and a trust is that only legal title in that trust property is assigned to the trustee on the basis that that person is required to deal with the property for the benefit of beneficiary. In short, equity is acting on the conscience of the trustee in his treatment of the trust fund or trust property rather than seeking to benefit a beneficiary. In contrast, the beneficiary takes only an equitable interest in the property. Neither trustee nor the beneficiary becomes absolute owner of such property, unlike the recipient of a gift who does become absolute owner of such property, which comprised the gift. If a donor intends to make a gift of property, then he will not be entitled to rely on the law of trust to validate such transfer if it fails to take effect as a gift. Therefore, the courts have established a clear distinction between the gift and trust. Now we will move to next slide here. In this case, what happened? D signed a letter which purported to dispose of shares in favor of his brother M. He delivered the letter to M together with the executed share transfer forms, but without a share certificate because it was in the custody of the company. Letter stated that I am, as from the day, holding 4,000 shares in the above company for you, ... from this declaration and letter. From the date of declaration, he holds such shares of the company for the benefit of M. That's the declaration he made. And thereafter, D argued. Now, after some transaction, they are not in good terms, then now D argued that the letter merely contained expression of intention to make a gift which was never completely constituted, and therefore was ineffective to vest title in M. The Court of Appeal held that, in fact, the letter contained a valid self-declaration of trust in favor of M. It would take effect immediately, and as a matter of law, this could only involve a deposition of beneficial interest in shares, as legal title could not pass before the share transfer forms has been registered. He has executed and delivered a stock transfer form. He clearly intended registration to occur in due course. The idea that D would hold the shares for M pending the registration could be made effective only by imposition of a trust. That's the idea here. Because now he has transferred, but he didn't give the certificate. Now he argues that no, I don't want to give anything, just I intended to do that, but not finish the matter. But the court said no, once you sign, once you gave the letter to him, the trust arises. That's why the idea here that D would hold the shares for M pending registration could be effective only by imposition of a trust. And this was what D had to be taken in law to have intended. A mere intention to make a gift is insufficient for this purpose. The principal distinction between gifts and self-declaration trust is that in the former, the donor transfers the right to another, whereas in the latter, settlor or the author of the trust holds the right for another. Now we will see the differences or distinction between trust and agency. What is known as agency? What is the powers and functions of the principal and agent? That you will study in your final year. Today we will see little bit agency. A trustee has full title to the trust property. An agent to whom the property has been transferred does not have the title. When the property transferred to trustee is the absolute owner of the property, legal owner of the property that we have seen. The agency, an agent to whom the property is transferred does not have the title. When a money is handed over with direction to pay it to another person, there is no vesting of ownership and there is no trust, only agency. When a money handed over to another person with the direction to pay to somebody else, there is no vesting of ownership. The money given to agent now agent is holding the money. That's ownership vested to the principal, not to the agent. And there is no trust, only that's the agency. Because if the ownership vested on the transferee, then it may be a trust. But if the ownership does not vest in the transferee, then it may be a agency. In an agency relationship, a principal instructs an agent to act on behalf of principal. This agency can take a number of commercial forms. Its legal form is that a contract between the principal and the agent, that the agent can act on behalf of the principal to effect a specific range of transactions. The trust bears some superficial similarities to this agency arrangement. At first blush, a trustee operates as a form of agent dealing with the legal title in a property according to the terms of the contract. However, there is not necessarily a contract between settlor and trustee or between the trustee and beneficiary. Furthermore, in agency agreement, principal would not ordinarily require the equitable interest in the property acquired by the agent in the way that the beneficiary under a trust acquires the equitable interest once the declaration of trust takes place or takes effect. Now, when you talk about trust, in the case of trust, once the trust is declared, then beneficiary getting some sort of equitable interest in the property. But in the agency, nothing at all. However, it may be possible for the principal to assert that the contract of agency would transfer equitable rights by means of specific performance. Most of the significant similarity between trustee and agent is in relation to the fiduciary obligations created by each office. The trustee and the agent, the trustees and agents of the fiduciary duties to the beneficiary and the principals respectively. Then both of these people, the trustee and the agent, have some sort of fiduciary relationship, fiduciary obligation towards beneficiary and principal respectively, precluding them from making unauthorized profit from their arrangement or becoming otherwise unjustly enriched. In the agency also, agent should not make any profit out of the arrangement. And also in the trust also we have seen that trustee should not use the property for his own benefit, and also trustee should not get any sort of benefit from trust property. However, the most significant difference is that an agency arrangement is based primarily on the common law of contract, albeit imposing fiduciary relations, whereas a trust relies on equitable control of the consents of the common law owner of the trust property. Now we will move to other slide here. When a person, by an agreement, entrusted management of the property for 10 years with a duty to keep an account and subject to payment of remuneration, it was held that such appointee merely an agent, not the trustee, because the first thing is there's an arrangement between parties. Second thing is payment of remuneration is given. But I don't say that in a trust remuneration should not be paid. It can be done, but still generally as a right, trustee should not claim any remuneration, but it can be given by deed of trust. Now, where a person an agreement entrusted in the management of the property, now the property vested to that person, then maybe a trust. Now here property never ever vested to that person, but property may be with the owner, but a person by an arrangement entrusted to see the management of the property. In that case, it is management, then he is an agent to look after the property, not trust. If it, in the case of trust, the property should be not the management of the property. The property should be transferred to other person, transferee. Then only trust may arise. When a person has been given management and control of the provident fund and the employee of the firm, such person is not a trustee but a manager. Because it is not his fund or the fund not given to him, only management control. That's the important part. Management and control of the property. The first case that we have management of the property. If the management entrusted to another person, he may be a manager or he may be a agent, cannot be at all a trustee. A person has been appointed as an agent by a person to purchase a property for him. After such purchase, the agent fraudulently sold the property for third party. The principal could get the recovery of possession of the property from transferee of the agent, because agent, not being trustee, could not convey the valid title of the property to the transferee. Because agent, actually the task given to the agent to perform certain work on that, there are certain functions. Then even if you purchase a property, as an agent, if you purchase a property, if you sell it to that is wrong, that cannot be done, because agent does not have the legal title of the property. Trustee is not subject to general control of the beneficiary, whereas agent is subject to control of the property. Now, once the trust is created, or as I told you several times, or the author of the trust is out of the picture. And also trustee is not subject to any control of beneficiary, but trustee must comply with the terms and conditions of the trust deed. But if he fails to perform anything, then the beneficiary can file an action to compel the trustee to perform certain function, whereas the agent always under control and supervision of the principal. Agents of the trustee. Now, agents of the trustee has some agents. Then agents of the trustee are not trustees. And beneficiaries cannot take action against the agents of the trustees. However, agent of the trustee is fraudulently involved in the breach of trust. He may be constructive trust. That's little bit difficult area. Now we didn't study the constructive trust. Now just you read this one, because constructive trust is another huge area, big area that we have to cover later. Now for the timing, just we can understand this one. If a trustee fraudulently sold the property to another person, if the person who purchased a property subject to trust only, he purchasing such property. If there's a property subject to trust, right? There's a property subject to trust. If I purchase that property, then I purchase that property subject to that trust. The agent of the trustee has fraudulently involved the breach of trust, then he may be a constructive trustee, because he fraudulently breach of trust. By breach of trust, he has taken the property, then he holds the property for the benefit of again the same beneficiaries and shall be accountable to the beneficiary. That we will study later very clearly. Agency is based in agreement between the principal and agent, but there is not necessarily any agreement between the trustee and beneficiary. This is an equitable principle. Those are the matters governed by equitable principles. An agent can involve his principal in liability towards the third person, whereas trustee cannot so involve his beneficiary. Agent arises by consent, whereas a trust may arise without consent. That's the difference between agency and trust. Now we will see, this is another interesting topic, the distinction between trust and fideicommissum. Section 3b of the Trust Ordinance declares that trust does not include fideicommissum. Fideicommissum has been received to Sri Lanka through Roman Dutch law, but the trust received into Sri Lanka through English law. The distinction between legal and equitable ownership is of the essence of the trust that we have seen. When the author of the trust transfers his property to trustee, that means the legal title transferred to trustee, equitable title transferred to beneficiary. That's the meaning. The idea is foreign to the fideicommissum. There is nothing known. This idea is not at all in the fideicommissum. In trust, legal ownership of the trustee and equitable ownership of the beneficiary are concurrent and often coexistence. Ownership of the beneficiary and ownership of the trustee, that's the thing. Legal owner. Who is the legal owner? Trustee is the legal owner. At the same time, beneficiary is the equitable owner of the property. Those are concurrent and coexistence. But in fideicommissum, ownership of the fideicommissary begins when the ownership of fiduciary ends. Then the fiduciary holds the property. Once he dies, then only the property will go to another person. The ownership of the fideicommissary begins when the ownership of fiduciary ends. The fideicommissum arises when the property is given to a person called as fideicommissary, who has the absolute control over it. The property given to fideicommissary, then the fideicommissary is the absolute owner of the property. Then what is next? On the death of that person, or on the happening of any other event or condition, property passes to another person called as fideicommissary, and may likewise devolve on successive fideicommissariés. Now keep on going downwards, down. So now say suppose father transferred his property to son under fideicommissum. Then on the death of son, it should go to the eldest son of that person deceased. Again the child dies after the 50 years or 70 years time. Then it should go to the eldest son of his father. It goes up, devolve, keep on going. But the thing is, once the father dies, the property devolves to son. But he can't sell, he can't dispose the property. He can use the property as an absolute owner of the property. That's why absolute control of the property given to the fideicommissary. Then if he dies, the property goes to the other fideicommissary. Then he must hold the property. He can exercise anything and he can enjoy everything, but he can't sell it again. Such a way it should go, keep on going like this. That's fideicommissary. That is known as fideicommissum. Now we will see the difference, because we know what is known as trust. Now we will see the differences between two concepts, trust and fideicommissum. In a trust, legal ownership of the trustee and the equitable ownership of the beneficiary are concurrent and coextensive. That's what you see. Now here, the legal ownership of the trustee In the trust, legal ownership of the property, trustee, the legal that's a legal owner is the trustee, and the equitable owner is the beneficiary, are concurrent and coexistence. Coexistence. But that's I think it must be a mistake. Just to correct it later. Then we will see here in the Fideicommissum, the ownership of the fideicommissaries begins when the ownership of fiduciary ends. In trust, interest of the beneficiary, though not described as equitable ownership, is against bona fide alienation of legal estate. It is ineffectual. The fideicommissary, once his interest has vested, he has the right which he can make good against the world. Then he has the full power to do everything. But keep it in your mind, abolition of Fideicommissum and Entails Act, number 13 of 1973, abolished Fideicommissum in Sri Lanka. Now there is no Fideicommissum in Sri Lanka. But whatever already done before 1972, if there is a deed of fideicommissary arrangement is made, suppose before 1972, before the abolition of Fideicommissum and Entails Act came into operation, if anybody transferred a property under Fideicommissum, it has the effect even after 1972. It will continue until such time. There is no problem at all. But after 1972, Fideicommissum is abolished. That cannot be done. Now also sometime, when you practice, you can see some people, they will ask to do that. Owner of the property or father maybe, father will come and ask you to execute a deed. It should go to son on my death. Then thereafter, it should go to the eldest son of his son or eldest son of that person on his death. But that is wrong and that it has no value at all. Therefore, keep it in your mind when you execute these type of deed as a notary public, you should not execute, because in the abolition of Fideicommissum and Entails Act, it's clearly provided that even if you do some arrangement like that, Fideicommissum, then it has no force in law. Right, then we will move other section here. That's the private trust and public trusts. What is known as private trusts? What is known as public? Now, when you study, there's a separate topic known as charitable trust. That we will study in detail later. Now, for the time being, for the purpose of understanding the differences between trust and other regime, now we will see this also. What is known as private trust, but what is known as public trust. But don't confuse with this other matter. This is also you must know. That's why I put it here. But actually we will study later in the charitable trust very clearly and in detail. When the beneficial interest is limited to a specified individual or definitely ascertainable individual, it is a private trust. Suppose I create a trust for my relatives known as 1, 2, 3, 4. Sometimes I create a trust for my heirs. That's clearly mentioned, the specified individual A, B, C, individuals named is there. All the names are given that these are the individual for whom I'm creating a trust. That's a private trust because you are able to identify the individual by name. That's a private trust. The private trust. That also trust, but that's a private trust. In a private trust, a person creates a trust by deed or will, that's a last will, providing for the enjoyment of the property by members of his family or descendant. That's why I told you now. Now, if I create a trust for my family member, that's a private trust. That's not the public trust. Or my descendants, then that's the private trust. That's specifically we must see whether the beneficiaries are named, then that's a private trust. When the beneficial interest for the public as a whole or section of the public, it is public trust. Now the trust is created. Say suppose it is in relation to the charitable trust. If a trust is created for the benefit of poor people in Sri Lanka, poor people of Sri Lanka, then it is the whole public in Sri Lanka. Or sometimes it may be a trust is created for the education of children in Sri Lanka. That's for the whole public. We don't know. Can you name those people? No, we can't, because the whole lot is there. That is for general whole public. Sometimes it may be a section of the public. I create a trust only for the benefit of Buddhists, then that is section of the public, not the general public, that is section of the public. Then it is a public trust, because we can't name them. We don't know how many members, how many beneficiaries are there. But as much as possible, we try to do something, or as we must give some sort of beneficial interest to that community, the poor people or the Buddhist people or whoever, whatever mentioned in the trust, we must help them. The public trust beneficial interest is vested, uncertain and fluctuating body of person, because we don't know how many members are there. We can't name them. We don't know them. We are not in a position to identify them. That's general public or section of the public. The public trust is constituted for the benefit of either public at large or some considerable portion of it answering the particular description. That's why the Buddhist. Then when you say Buddhist community, that's little bit particular description given. That forms a section of the general public. The duration of private trust cannot be extended beyond the period allowed by rules of perpetuities. Section 110 of the Trust Ordinance provides the limitation of period of the trust. The duration of private trust limited by perpetuity rule of the Trust Ordinance. But public trust may be permanent and indefinite character, forever. Now suppose the fund is deposited in the bank, 1 million rupees deposited in the bank for the purpose of giving some sort of benefit to the law students of the law college for the education purpose. Then you can't withdraw the fund, because keep on going years and years and years, because that's a public trust. But if I create a trust for the purpose of my heirs or legal representative education, that is the private trust that will be governed by perpetuity rule. That's 110 of the Trust Ordinance. That is the main area that we have to cover in these lectures. Now we have seen what we have studied now, simply the differences and similarities of trust and other legal regimes or legal concepts. The first place we have seen the trust and gift. Gift also some sort of, in a way it is given to, absolutely given to other person. Here also in a way we can say, author of the trust transfer the property to trustee absolutely. Then we have seen the agency. When you talk about agency, there's a principal and agent. There's an agreement in between principal and agent. Always agent subject to the directions of the principal. Agent does not get any ownership of the property. Just he holds a property to execute whatever directions given by principal. But in the case of trust, once a property transferred, the trustee is there, then in equity he must hold the property for the benefit of beneficiary. Then finally, fideicommissum, that's very simple. Fideicommissum is different, totally different from trust. Fideicommissum, once the property transferred, the transferee must have the power to enjoy in full, absolutely the property given, but he can't dispose the property. On the death of that person or any event happening, then the property must devolve to another person as specified in the deed. Then on that, another person must hold the property, enjoy the property, absolute owner of the property. Once anything happens or once he dies, whatever mentioned in the Fideicommissum deed, then it should go to another person. Then now if somebody wants to keep the property in the generation, in their generation by generation, if they want to keep the property within their family, then they execute. But now it is prohibited. Now you can't do that because that is abolished. Then what you should do is now you can, even if you do it, that's it deemed to be a transfer to first person to another person, second person. That's all. Even you can say everything, but it does not effect in law. It has no effect at all. It may be or may be deemed to be a absolute transfer to next person. Then because that is absolute, that is abolished. Whatever it is, already done before 1972, if the Fideicommissum executed, that will continue without any trouble. Then we have seen the public trust and private trust. Private trust simply for the private members. Beneficiaries must be a private members. Must be some sort of blood relationship. Or some other way also, not only the blood relationship, some relationship must be there. But public trust in the sense, it is the beneficial interest to the general public or section of the public. That is the end of these lectures. Thank you.